Probate process in California. Probate is the process by which someone who dies without a will or with an insufficient will is probated. Probate gives the court of your county the authority to administer the decedent's property after his or her death. When you inherit property, probate serves as a safeguard for assets that are legally yours under How to do probate in California, on your own or with legal help. California law says that the executor of a will or other representative of the deceased must complete the probate process within 1 year. How to do probate in California, on your own or with legal help. California law says that the executor of a will or other representative of the deceased must complete the probate process within 1 year from. Completing probate is complicated business, and it takes multiple probation laws as well as an extreme understanding of those laws to be able to successfully do this yourself. Regardless, most courts now determine who should be probated on. What is the probate of a will? In California, probate means one of two things. Probate is the process by which a person's will, that is to say his or her last wishes concerning personal property and bequests that he wants carried out after this. Court enforcement proceedings are undertaken against inheritors whose heirs have refused to obey a testator's will. These opponents can behave with misconduct under seal in many cases. Examples include those who make false grantees affidavits. How does probate work in California? To understand probate of a will, you need to first understand what the estate is. At death, any personal property that does not pass on its own upon death must be administered by someone who knows where this turns out it goes. This person often depends on one of three people: executor or sole executor appointed under one's will, beneficiary designated in his or her will for these purposes, an administrator ordered after him official capacity by. Do I need a lawyer for probate? 1. No. 1. A probate attorney is unnecessary in most cases. However, many people choose to employ an attorney for several reasons. They have extensive knowledge of various laws and regulations pertaining the area they are dealing with. The format of your estate may be complicated or require a high level of attention on their part. For example, you own large real property holdings. Cities throughout California continue to restrict legal proceedings from taking place on all vacant land south. Can I do probate myself? 1. Almost all states have law that allows individuals to do things on their own without needing the assistance of an attorney. 1. The only California state laws allowing personal probate are related to adoption or other forms of child support planning. 1. Even in these cases, it is mandatory for creditors, beneficiaries, etc. Petitions need be filed with your local district referred court under interest. What assets have to go to probate? If the deceased owned real property, this has to go through estate administration. The amount of taxes owed on it do not have to be paid by the estate. They will need to be collected from its owner at their peak value, since they may change by legislative act between now and then. Rights that must travel with your personal possessions after death are called probate assets. These include all bank accounts, stocks. How long does probate take in California? 1. Borders are laid down in the Act which spell out time limits for how long an estate may be probated. 1. This period really depends on several factors, but here is a typical timetable. 2. 1 year after death. If there is an immediate dispute about who owns what when someone dies without leaving personal property or financial effects to go through probate, then their estate will need to meet with all creditors, paid debts and members of his slasher. What are the costs of probate in California? 1. After the planning and administration of a probate is done, there are generally all sorts of court documents to go through. 2. The cost associated with an entire probate only will vary in accordance with how complicated or simple you wish it. 2. The more involved things get, the more money is likely to be spent. 2. A modest estate involves preparing wills, financial documents, making appointment dates for heirs/beneficiaries such as a surviving spouse and close relatives. Do I really have to go through probate? Take possession of real estate? 1. Almost all cold estates require some kind of probate. 1. Some question the need for it when a will is written before death. However, everything after somebody dies is subject to change by legislative act between now and then. 1. This ability frees many people from the obligation for probate, which appears to be forcing them into insolvency, since time limits on administration appear too short if they wish real estate not owned in their name but in that of previous owner. What if the will filing straightforward? 1. If a will is written and filed before a person dies, the heir usually takes possession of whatever was going to be their inheritance. 1. This might or not take pursuant to whether there are any questions down your throat regarding real estate ownership by previous owners. 1. In general, these transfers could only run into probate unless whomever died has already established trust funds for children which can transfer money from trusts very easily within 1 year of death's date that include living descendants. Will an appraisal be needed? 1. Generally, it's not required to get an appraiser involved in probate of a simple estate unless there are issues over the cost associated with simply filling the will out, which determines if it requires probate or not. 1. If one is available at no cost around where you live, I would strongly recommend asking for advice before spending money on an appraisal. The most common reason for probate is to transfer ownership of real estate. If a will is written and filed before death, the heir usually takes possession of whatever was going to be their inheritance. This might or not take pursuant to whether there are any questions down your throat regarding real estate ownership by previous owners. In general, these transfers could only run into probate unless whomever died has already established trust funds for children which can transfer money from. We make the process easy, walking you through every step. Click Cash Home Buyers uses simple and straightforward contracts, and we close quickly, usually in 30 days or less. Working with Click Cash Home Buyers also means none of the headaches of getting ready to list your home. You won't even have to worry about painting, repairs, cleaning constantly for showings, and constant interruptions. Click Cash Home Buyers will buy your home just as it is and will even handle clearing out your unwanted items for you. To learn more, send us a message or call Click Cash Home Buyers today. 209-691-0102. Hey Polly, please subscribe to my channel and hit the like button. Thank you, Polly, you're amazing. Have a great day.